Welcome to the NJ Criminal Podcast.
In 2016, a jury convicted Michelle Lodzinski of murdering her 5.5-year-old son, Timothy Wiltsey, in 1991 after his disappearance from a carnival in Sayreville, a crime that she wasn't charged for until 2014. On December 28, 2021, the New Jersey Supreme Court vacated that murder conviction after agreeing this past October in what was considered to have been a stunning and highly unusual decision to reconsider its own May 2021 decision affirming her conviction. In that decision, the court had ruled that the appellate division had applied the wrong standard when it found that there was sufficient evidence for the jury to convict her, but after applying the correct standard, tied 3-3 on the issue after Chief Justice Rabner recused himself from the case, thereby affirming her conviction. In agreeing to reconsider that decision, a newly formed majority, created by the addition of Justice Joseph Fuentes, the appellate division judge most senior in service, who sat as the 7th member of the court granted reconsideration on the ground that the 3-3 split left in place a constitutionally defective appellate division judgment that had reviewed the sufficiency of the evidence under a standard that violated both federal and state law. In the December 28th decision just 2 days ago, after reviewing the entirety of the evidence and after giving the state the benefit of all of its favorable testimony and all the favorable inferences drawn from that testimony, the court held that no reasonable jury could find beyond a reasonable doubt that Lodzinski purposely or knowingly caused Timothy's death, and that even if the evidence suggested that Timothy did not die by accident, no testimony or evidence was offered to distinguish whether he died by negligent, reckless, or purposeful or knowing acts of a person, even if that person were Lodzinski. The dissent stated the decision usurps the exclusive province of the jury that heard the evidence at the defendant's trial, and stated that they considered that the decision was a disservice to the jury system and a grave injustice to the victim, 5-year-old Timothy Wiltsey, and respectfully dissented. Take a listen as I talked last week with Jeff Horn, New Jersey family law attorney and host of the Bold Sidebar, where we discussed the procedural complexity of the case in anticipation of the December 28th, 2021
Welcome
decision.
to the NJ Criminal Podcast.
You know, my take on this as I went through it at the end of the day was that I think sometimes smart people, and I would say that lawyers and judges are very, very smart, make mistakes. And there were quite a few mistakes, in my opinion, based on my review of the procedural history in this case. So, you know, I know that you've gone through this case a little bit, but I do think that the background and the facts of the case are worth at least mentioning. So, Timmy Wiltsey, born in 1985, as you said, went missing in 1991 from a carnival in Sayreville. His remains were found in 1992. And, you know, Mom Lodzinski, Michelle Lodzinski, gets questioned, gives a number of kind of conflicting stories about what happened when he went missing at this fair. I think at some point I read she gave at least half a dozen conflicting different stories about, what happened that night. 20 years go by and no one is charged. She moves down to Florida, has 2 more boys, gets on with her life. And in 2011, the case gets reopened. One of the detectives gets a tip that ends up not panning out, but it results in the case being reopened. And ultimately, a decision is made to charge Miss Lodzinski in 2014. There is a trial, 28-day trial in 2016. And at the conclusion of the state's case, her attorneys make a Reyes motion, basically, asking that the court, find that she, there was not enough evidence to support a conviction at that point. That gets denied. She gets convicted, found guilty by the jury, and after the guilty verdict, the defense attorneys again raised the issue of judgment of acquittal notwithstanding the verdict, right? Saying, hey, evidence was insufficient to support the jury's verdict of guilt beyond a reasonable doubt. And without getting into all of the facts of the case, it's important to note that no forensic evidence tying her to his death. There was a medical examiner that had initially examined the remains, and it was a skull. I think there was some bones, but not a complete body. He had passed away by the time the trial came around, so the state had called another medical examiner as a consultant who reviewed his work and testified, and couldn't come up with a cause of death, right? So there was really very little direct evidence linking her to his death. And ultimately, however, the trial court examined both the evidence that was presented by the state and the evidence that was presented by the defense and denied the application, the motion for judgment of acquittal notwithstanding the verdict. She gets sentenced to 30 years, must do 30, and that was in 2016. In following that, she appeals. In 2019, and the appellate division, Judges Massano, Faciali, and Rose, rendered a decision affirming her convictions. One thing I think it's important to note, the appellate attorneys that she had in 2019 are still her appellate attorneys, right? They have remained, and that'll become important, I think, in a little bit. So the problem with the appellate division's case, as we learned when we read the New Jersey Supreme Court decision earlier this year, is that the appellate division, in reviewing the question of whether or not there was sufficient evidence, only looked at the evidence that was presented by the state. So when the New Jersey Supreme Court earlier this year, reviewed the appellate division, it was a unanimous determination that the appellate division had applied the wrong standard. All of the justices agreed on that point. Now, the other thing that's important to note is that, there's normally 7 New Jersey Supreme Court justices, but Justice Stuart Rabner had been at the Attorney General's office when there was for a period of time early in the case, when the boy was missing, the FBI had gotten involved. There was a federal investigation. So he had been at the AG's office during a part of the investigation and said, I'm going to recuse myself. So, New Jersey Supreme Court decision, you're left with 6 justices who, again, unanimously agreed that the appellate division had applied the wrong standard and evaluated that claim of sufficiency of evidence under the proper standard. The proper standard being looking at both the evidence presented by the state and the evidence presented by the defense. Again, trial court had done that when it initially denied the judgment of acquittal notwithstanding the verdict, but the appellate division, in their opinion, back in 19 had not. So, and the other thing I think it's important to note is that the appellate attorneys, again, same one she has now, had in their brief to the appellate division applied the wrong standard. So, mistake number one was the appellate attorneys using the wrong standard before the appellate division utilizing the wrong standard in their decision. And then when it went up to the New Jersey Supreme Court said, okay, appellate division, applied the wrong standard. Of course, now same appellate attorneys are, highlighting that fact. But in any event, because Rabner had recused himself, although there is a provision that would have permitted another judge from the appellate division to kind of step up and fill in, pinch hit, so to speak, they didn't do that. And so what ended up happening was, in my opinion, mistake number three was didn't bring up a seventh judge. So when the New Jersey Supreme Court analyzed the sufficiency of the evidence using the proper standard, guess what happened? Split 3-3. And, I went through the opinion. Justice Albin wrote a scathing dissent, basically pointing out the fact that there was in his opinion, there was no direct or inferential evidence of how Timmy died, circumstances of his death, and basically, went through the facts to point out the fact that, yeah, she might have given conflicting statements, but that, in his opinion, was not enough, was not sufficient to sustain the guilty verdict. He states, though, sadly, the murder conviction in this case will stand despite the utter absence of proof that she purposely or knowingly killed her young son. So that was the decision of the New Jersey Supreme Court earlier this year, May 2021. What happens next? Well, the appellate attorneys, again, same ones that she's had, I believe, same ones that she's had, asked the New Jersey Supreme Court to reconsider. So they filed a motion for reconsideration of the May opinion. And what's important to note here is that the court rule in New Jersey related to motions for reconsideration provides that a motion for reconsideration will be granted only if it is moved by a justice or judge who concurred in the judgment or decision and a majority of the court so determines. That's very, very important because if we look back at the Supreme Court decision in May, we had Justices Patterson, Fernandez-Vina, and Solomon on one side of the equation. And on the other side of the equation, we had LaVecchia, Pierre Lovis, and Albin. So the first three felt that, the applying the correct standard, the conviction should stand. The second group of three that I just stated, applying the correct standard, felt that there was not sufficient evidence. So what that means is, in order for her appellate attorneys first to even be able to ask the New Jersey Supreme Court to reconsider this, decision, they would have to be able to establish that one of the justices that concurred in the decision, right, agrees that the motion for reconsideration should go forward. The three justices that concurred in the decision or of the appellate division were Patterson, Fernandez-Vina, and Solomon. Okay. None of those three justices agree right now with the court order that just came out on October 6th of 2021, granting the motion for reconsideration. So, I guess I should have started all of this by saying the New Jersey Supreme Court, in what is an unprecedented decision, has granted reconsideration of their May decision. Now, what has happened is that the court has now decided, hey, maybe we should have had a seventh judge, right? Should have probably had the foresight to, think that there may be a split vote, a tie vote. So now what they've done is they have, in fact, brought up a judge from the appellate division to kind of weigh in. And that judge is Jose Fuentes. So he's now been assigned by the presiding justice, as he is the senior most member of the appellate division, to kind of be that seventh judge. All right. And what is now the majority in the granting of this motion for reconsideration has basically come to a what I will say is kind of skirt around to some extent this rule. It's Rule 2:11-6A. That's the rule related to motion for reconsideration, to basically fix the procedural mistake of not having added this seventh judge to begin with. And so, the way they're doing it is that, remember a couple minutes ago, I had said that all of the justices, all 6 of the justices, had agreed that the appellate division had applied the wrong standard. They did agree on that. And so now, in order, because there's no way that the New Jersey Supreme Court can even hear this motion for reconsideration unless they find that there is a judge that, was on the other side, that concurred with the lower opinion and now agrees to this, motion for reconsideration. So what they're basically saying is, well, there was in fact, a judge that, concurred, because remember, all 6 justices concurred in the quote decision, which held that the appellate division applied a substantially and constitutionally incorrect standard. So they kind of get around that fact, and that's something that, there was an order that came out this past October 6th, and Justice Patterson, who had parenthetically written the concurring opinion in the Supreme Court's decision in May, she wrote a dissent to this order granting a motion for reconsideration, where, she is absolutely adamant that there is no authority for this motion to reconsider because it's just not being adhered to. She's saying all 3 of us that disagree with the granting of this motion for reconsideration are all of the 3 justices that, agreed with the ultimate analysis by the appellate division to affirm the conviction. So, she's kind of, not happy with the fact that her agreeing and writing the concurring opinion in the New Jersey Supreme Court decision from May is now kind of being twisted around to say that, hey, you're one of this, all of us, all 6 of us, concurred. So my take on the whole thing, again, and I'm anxious to hear your take, is that it is set forth in Justice Albin's concurrence on this order. So basically, this order comes out in October. There is a recitation of this procedural history. It is they're going to be back, before the court for argument in the next session. And Justice Albin writes a concurring opinion, which basically says that, with the benefit of hindsight, it's now clear that the court had only two viable options when it reached a stalemate. Either remand to the appellate division to review the evidence under the proper standards set forth, right? And call up the senior member of the appellate division to sit as the seventh member of the court to break the deadlock. But proceeding as we did was a mistake. And this 3-3 split was a mistake. And what we want and what should happen is the opportunity, to fix the mistake. The mistake being not calling up a seventh member, to serve and kind of break the tie. So, when I look at the whole, from kind of soup to nuts of the procedural history, I think that this is kind of an example of there's a lot of really smart people involved, right? These appellate attorneys, obviously, they're being, they're very creative to even bring this motion for reconsideration. As we know, this does not really ever happen. Again, claiming that the incorrect standard was applied, although, again, as I mentioned in the beginning, in the brief to the appellate division, the incorrect standard had been applied by the appellate attorneys, but nevertheless, it's now being used to kind of get that second bite at the apple. So mistake number one, wrong standard applied by appellate attorneys before the appellate division, wrong standard by the justices, the appellate division that decided the case back in 2019, and then and again, I'm certainly we all have the benefit, I guess, of hindsight, as Justice Albin just said in his concurring opinion to the granting of the motion for reconsideration. But Monday morning quarterbacking, it's clear that there should have been a seventh judge brought up, since there was the ability to do that. Now, Justice Patterson, she goes through again the facts of the case, and she's like, how in the world can Lodzinski claim that she hasn't had a review under the appropriate standard? That's what we did. How can they claim that, a 3-3 tie is somehow unconstitutional? We do it all the time. How in the world can, this court even come to the conclusion that a motion for reconsideration is proper, since the rule, as I've stated it, is not being followed? They're just basically doing it and kind of trying to, skirt around that motion for reconsideration rule. It's not being complied with. There are no justices that concurred with the appellate division that now agree that this motion for reconsideration should be heard. And so, again, at the end of the day, there's just a lot of mistakes which have now resulted in a very long, complicated procedural history. But Justice Albin, as he stated in his, dissent, both in May and then again this past October, and it's no secret that Justice Albin is probably one of the more liberal justices on the bench, really points to the fact that this is a case of great magnitude, and it is one that, when you have someone who is convicted of murder and is now sentenced to 30 years must do 30, there needs to be a proper review. And he basically, as he stated in the dissent, that this due process was not applied, was not achieved in this case. So it's a lot to take in. It's a whole lot to kind of sift through. And I was curious, what your take was of this most recent twist, the granting of the motion for reconsideration?
Well, thanks. And first of all, I love how you break down the motion for reconsideration rule, which honestly, I've never even heard of the motion for reconsideration rule in the appellate division or the Supreme Court until this case. I didn't even know we had it or existed. So I thought it was very, very creative. I think it's Cravatin is one of the lead attorneys for Lodzinski, who's been fighting this battle for a bunch of years now. I've said a lot about this case, but since I have you, I get to dig into a couple other things. First of all, this idea of an equally divided affirmance, I hadn't given that a lot of thought. And I just wonder if going forward, if the court might sort of create its own informal rule that at least if we're talking about murder cases, we're talking about people who are going to be in prison for the rest of their life, in all likelihood. I mean, Michelle Lodzinski's got to be about 50 years of age now. And the 30-year term, it's the same as a death penalty, essentially. Whether they might just sort of automatically do that. In the past, they have done that with Judge Cuff. Judge Stern, over the years, brought up that seventh justice to get an odd number going and avoid this weird thing where, as you say, Justice Albin wrote a passionate dissent, and then Justice Patterson wrote, and I had to ask my friend Bruce Greenberg about this, she wrote a concurring opinion as part of the per curiam opinion. So it's not even her opinion, weird enough, that they don't have a justice that says, this is my opinion, I'm going to give you all the facts. And Justice Patterson wrote the facts like she's writing a Netflix special. I mean, it's boom, 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 fact, fact, fact. Mm-hmm. Really, really well put together and cataloged. So I just got a lot out of that aspect of the case. But really, I wonder, the takeaway is, are we going to see another case like this on circumstantial evidence, right? Because this is, like you said, there's no forensics, there's no eyewitnesses, there's barely anything. We just have a dead 5-year-old and a mom with a terrible story, and then very little beyond that.
Well, right. I mean, she's convicted based upon the fact that she kept changing her story about what happened. And, that in and of itself is, the question becomes, is that in and of itself enough to prove that she did it beyond a reasonable doubt? And the other thing that kind of struck me as I was reading the facts, and I agree, I mean, the recitation of the facts by Justice Patterson is riveting in the May opinion. But the thing that struck me was, back in 91, 92, they weren't recording interviews, audio and video. That was before. Now they may have, but they weren't required to. And so I wondered, had those interviews been recorded, if there would have been a different kind of presentation as to what actually happened and what actually she said.
Right. That you're so right. The recording of the interviews, the videotaping of all these interviews now, and the proliferation of surveillance cameras. If you go to a carnival and you've got your kids, grandkids, or whoever, you're shooting videos, you're taking snapshots and selfies. So a canvas of everybody at the carnival would have put this picture together, right?
Well, and
that 30 years ago.
And she probably would have had a cell phone where the police would have gotten it, and they would have gotten a CDW and been able to find out exactly where she was.
That's exactly right.
Right. I mean, so many cases I have now, we would expect, communication data warrant type evidence. Didn't have that back then. And I like how you tease a case we're going to talk about with CDW and GPS and all that in a few minutes. Right. Well, there's coming up. So, I mean, I think the question that I had was, why do you think they did not appoint a seventh justice? That to me, I mean, is, and I don't, I'm not an appellate attorney. I'm not. I like reading these decisions and kind of, I guess playing Monday morning quarterback, obviously. But it surprised me in a case of this magnitude that when Chief Justice Rabner recused himself, no appellate division judge was assigned to temporarily serve on the court and hear the appeal. And there is a footnote in the recent order. Actually, it's part of Justice Patterson's dissent, where it's noted that, the Chief Justice may, in his discretion, assign an appellate division judge to temporarily serve on the court, in certain settings. One setting in which would apply would be when, they're short a justice, and they don't have a full complement of 7 justices. I wonder if this, it's kind of a debacle at this point, whether or not it will change, how the court operates. And, the other thing that kind of struck me was that and I'm curious on your opinion on this if you want, in looking at how the court is now finding that the motion for reconsideration rule has been complied with, they really do a little bit of a dance to get there. And that's Justice Patterson's biggest complaint in her dissent to this recent order. This is kind of an example of a very broadly read statute to achieve a particular purpose, to basically correct the fact that they didn't have a 7th justice and they probably should have.
Yeah, I agree. It's a shoehorn. I don't know how much value this opinion would have for future motions for reconsideration in the Supreme Court, but certainly it will give rise to attempts to look to reconsider. And back to another point you were making, I was asking Alexander Shalom from ACLU, who has handled hundreds of cases in the New Jersey Supreme Court, and I was asking him, are you able to request in advance, if you know there's going to be an equal number of justices, are you able to make an application in advance to say, hey, this is really important. We want to make sure that we have an odd number of jurists handle the case. And he says, no, you don't even know if a justice is going to recuse himself or herself until you get to the argument. So there's not advance notice on that. I didn't know that either, sort of wondering, is this something that could have been preempted, something that you can request? So, it's just a little tiny area of our law, but it creates the fireworks because it's the Supreme Court and it's a murder case and it's a dead 5-year-old kid.
Right.
And it's a pain for this family and everyone around this case going on 30 years. So I'll be thrilled to talk about this at least one more time.
Right. Any predictions on what Fuentes will do? I mean, is it going to come down to him?
I imagine
that's a lot of pressure.
I don't imagine.
Right?
I wouldn't imagine that either of the concurring group or the dissenting group is going to have an ounce of change after even another argument or another round of briefs, or I don't even know exactly the extent to what they're doing. But
I think the 3 and 3 seem pretty entrenched in their position.
I agree. I really agree. And I guess when I read it, if in 2021 you can still have a circumstantial evidence case for a murder, which is obviously as heavy as it gets, this case is that. There's no other sort of way to look at the case, use her own words against her, et cetera, et cetera. Mm-hmm. However, I was struck by Justice Albin saying, you have proof of death, you have proof of a young woman who acted suspiciously from the first minute and days, in the days after the disappearance of the child. and then you've got a blanket and some Mutant Ninja Turtle sneakers or shorts, and that's all you got. So how do you put together the elements of the case for murder based upon those pieces? You may have another crime that you could hang on Michelle Lodzinski, but it's tough to put it together. And again, we live in this weird, everything's got to be on video. Everything's got to be scientifically proved, right? You go back to OJ and Barry Scheck destroying the DNA expert in 96 or whatever that was.
Right.
That set the marker. Juries want science in order to convict people for serious crimes. So to be determined. I wish I had some sound effects. I can make them right now because I'm really interested in how this pans out. And I guess it'll be in 2022 when we'll find out.
We will, and we'll have to have a follow up and see where it went.
That'd be fine with me. All right, I have beaten up my audience with Lodzinski enough. If they don't like it, they would have quit by now.
Right,
I talked about it probably 6 times. Every time there was some twist and turn, I would jump back.
Thanks again for tuning in, and don't forget to subscribe anywhere you listen.